The U.S. Supreme Court will review a lawsuit filed by Hobby Lobby against the federal government. At issue, the Affordable Care Act mandate that employers provide contraceptive coverage in their health plans. Hobby Lobby is particularly opposed to providing coverage for the morning after pill. The owners of the Oklahoma City-based company argue the mandate violates their religious rights. Attorneys say it's a textbook case of the government imposing a substantial burden on religion. Joining us now from the Oklahoman's offices in Washington, D.C. is Chris Castile. Sir, thanks for your time today.
Absolutely, Dave.
Well, this is probably the last brief that Hobby Lobby will file in this case before the Supreme Court justices hear oral arguments, and that'll be on March 25th and then rule sometime this summer. Chris, what did the company emphasize?
Well, they hit all the main points, all the legal arguments under the Religious Freedom Restoration Act, which is what's at issue in this case. But what jumped out at me, or what struck me, was they really focused on what you just mentioned, the substantial burden. I mean, this law, this 1993 law, does not allow the government to impose a substantial burden on the free exercise of religion. So, what is that? A substantial burden. Well, what Hobby Lobby is saying is that obviously the government, the U.S. government in this law, in the Affordable Care Act, recognized that this contraception mandate was some kind of burden because it exempted a bunch of religious groups, churches, and others, very closely aligned with a certain religion. They exempted them from this mandate. So what Hobby Lobby is saying is, well, obviously the government recognized in this law that this mandate would impose a substantial burden on these groups. So, what's the difference? I mean, that's what Hobby Lobby is asking. What's the difference? So if it's a substantial burden on them, why is it not a substantial burden on Hobby Lobby? And what the argument is going to be, the first threshold that the Supreme Court justices are going to have to get across in this case, as you know, is whether Hobby Lobby, as a corporation, even a privately held one, closely held one, is protected by this law. A lot of the argument, from the two sides, and a lot of the outside groups that have submitted friend of the court briefs in this case, the argument is whether a corporation has these rights. Because corporations are, kind of distinct legal entities. And the question is, do they have the same rights as an individual, same religious freedom rights as individuals? And under the law, if they do, then if corporations do have this right, then the government can impose a substantial burden on their free exercise of religion, unless they have a compelling interest to do so. And the whole issue of whether the contraception mandate is a compelling interest, obviously, is the topic of some debate in this case as well.
We're chatting via Skype with Chris Castile in Washington, D.C. And Chris, you touched on my next question a little bit, but go into it in a little bit more detail. What's the potential impact of this case?
It could really be a major case as far as religious freedom in the country. And there's, again, I mentioned a lot of these, friend of the court briefs, all kinds of outside groups, have opined on this, on the implications of this. If the court were to say, as they did in a campaign finance case a couple of years ago that everybody knows about, Citizen United, that corporations have free speech right, and you can't limit, their involvement in donating money to campaigns. If they also have the same exercise of religion that individuals do, well, what does that mean for how corporations run themselves, and and what kinds of sort of religious practices can a corporation impose on its employees? So, that is obviously, kind of what everybody's focused on in this case is, the idea that corporations have, religious, freedom rights, and what would they do then? Some people argue that, well, if they should be shielded from providing certain kinds of contraceptives, and that, by the way, Hobby Lobby doesn't object to all of the contraceptives mandated under the law, just some that they consider, induce abortion. But if, let's say a corporation is granted these rights and their owners don't believe in vaccines, or they don't believe in, certain cancer treatments, well, what happens then? And so, that again is the basic issue in this case. But also, just in a more narrow sense, as far as the Affordable Care Act, it has implications about the whole idea that one of the goals of the act was to kind of equalize the treatment of women in health care, that they not have kind of higher costs proportionately than men do. And this was a way, these contraceptives are supposed to be provided at no cost to women. And this was a way, to kind of, as I say, equalize the treatment under health insurance for women. So it obviously has implications for that as well.
Oral arguments expected March 25th in the Supreme Court. And Chris, I guess we should touch on when we might expect a ruling.
It will probably be one of the last cases. I think the term ends sometime, mid to late June. So I think you could probably expect it to be one of the last cases to come down. So you're looking at sometime in the summer, Dave.
Very good. Well, you said the magical word there, summer, as we're dealing with a lot of winter and you have more winter heading your way.
Seems like an abstraction, yeah.
Chris, thanks for your time and thanks for the analysis.
All right, Dave, glad to do it.
More coverage from Chris Castile can be found in the Oklahoman and online at newsok.com.